There's an order on the Lively Wayfarer docket that involves Jonesworks and Abel. Let's go through it. When Lively filed her complaint against the Wayfarer Parties in December of 2024, she included claims against Abel, who is the publicist that used to work for Stephanie Jones in Jonesworks that supported Baldoni and Wayfarer. Now, as many of you know, Lively amended her complaint a couple of times, so we're up to the second amended complaint filed in July. And each of those times that she filed her amended complaint, a response is required from the defendants. So Abel, being one of the defendants, had to respond to those complaints and amended complaints. So starting with the first complaint that was filed, Abel filed an answer, which is required of a defendant to essentially contest the allegations that are provided by a plaintiff. That's an opportunity for a defendant to bring cross complaints against the party or bring in other claims against other parties. So Abel answered each time that Lively amended her complaint or filed her initial complaint, and she countersued not against Lively specifically, at least this is the one that we're focusing on today. She countersued against Jonesworks, seeking indemnification for liability that is potentially at issue in the case that Lively has against the Wayfarer Parties. So this is a third-party complaint. Lively sues the Wayfarer Parties. Abel is within the Wayfarer Parties. Abel answers Lively, and she also files a third-party complaint against third-party Jonesworks, who's not technically within the Lively versus Wayfarer case. Yes, there's a separate lawsuit. We're not talking about that separate lawsuit here. We're just talking about the lawsuit between Lively and the Wayfarer Parties. Abel is saying, to the extent that I'm found liable for anything that Lively is saying that I did, to the extent that those allegations are respect to actions that I took as an employee of Jonesworks, then you, Jonesworks, should be liable as well. You should indemnify me for the cost of having to defend the claims against me. So Jonesworks now has to answer to a third-party complaint. So Jonesworks is now party to this third-party complaint, has to answer. Instead, they moved to dismiss and said that the employment agreement nullifies any requirement to indemnification. So first, the court goes through a very complicated analysis of determining whether the choice of law provision in Abel's 2021 employment agreement applies to the first cause of action that Abel brings. Essentially, because Abel had some contacts with New York, entered into an agreement with a New York company, the first validity of the choice of provision is confirmed, but then looks at how broad that provision is. The court determines that the provision is only broad enough to include claims that arise out of that employment agreement itself, not claims that are incidental to it. And here, Abel's first cause of action alleges that Jones has an obligation under California law because of their employee-employer relationship to indemnify her for claims that are incidental to her work. So because this provision in the 2021 employment agreement is narrowly interpreted to cover only claims arising out of that agreement between Jonesworks and Abel, the court here is saying that the New York provision would not apply. California law would apply. So the court is required to do a conflict of law analysis, which is basically to see, is there a conflict? Here, California has this requirement, has this law, where New York does not. And because the parties had not briefed that piece of it, and it's fact intensive, it falls outside of what a motion to dismiss could consider. And so the court says that it does not have enough information to make a determination of that conflict of law analysis, and for that reason cannot grant the motion to dismiss as to the first cause of action. The judge further goes into a detailed analysis of common law indemnification and says that Abel's claim for recovery under common law indemnity may proceed if she plausibly alleged that Jonesworks was vicariously liable for the conduct in the underlying action, meaning that the action that she took, that she's being sued for, was under the direction of Jonesworks. Therefore, Jonesworks is vicariously liable for the stuff that Abel could be held liable for. Here, Jonesworks argues that there's no vicarious liability under this legal theory called respondeat superior, Latin, but says that they're not vicariously liable because Jonesworks acted on her own, was acting outside of the scope of her employment. Abel says, everything that I did under the direction of Jonesworks. Everything that I'm being sued for, I did under the direction of Jonesworks. And Jonesworks is saying, no, everything that you did at your own direction. So Jonesworks is not vicariously liable under respondeat superior. Respondeat superior is a Latin phrase that literally means let the master answer. So it's a legal concept that an employer should be liable for what an employee does within the scope of their employment. So if you're working for an employer and you're required to drive to city X and you drive into someone and hurt someone while you're doing that for your employer, then the employer is required to not indemnify you, but is responsible for the harm that you caused someone else because of your work for the employer. The court agrees with Abel here and denies Jonesworks' motion to dismiss on that cause of action. So that is responsibility for, vicarious liability for. The third piece is about contribution. So should Jonesworks be responsible to pay for whatever costs are associated with any liability that is found on Abel? And where Abel shows that Jonesworks caused the same injury to the plaintiff, she shows that the parties must have contributed to the harm to the plaintiff, and therefore stated a cause for damages to be sought from Jonesworks to recover damages for that contribution to Lively's potential damages. So the motion is denied, and Abel is able to continue pursuing indemnification from Jonesworks. So we are likely to see more stuff about this coming out. Probably not until summary judgments are done or trial, because ultimately what this is saying is Abel is claiming that Jonesworks should pay for her defense in the Lively matter, and that's ongoing right now. So those claims are not really ready for a court to decide exactly to what extent, how much, what are those bills going to look like. So this is something that will come up after all of the stuff that's happening in the Lively Wayfarer case. The interesting thing is that when an employee gets sued or a former employee gets sued of an employer and an indemnification issue comes up, usually what happens is the employer or former employer will take over and will get representation, will select lawyers, will sort of take over the defense of that lawsuit. And here that would be really interesting. That would be like Jonesworks having to hire competent counsel to defend Abel in her defense against Lively. So that's a really kind of interesting legal nuance here that I'm curious, like what the conversations are behind the scenes, because I'm sure that Jonesworks is not going to be happy to foot Brian Friedman and Kevin Fritz's bill at the end of this, especially because they're adversaries. Jones has sued Abel. So it just really complicates things even more. Oh, the tangled webs they've woven.